All right, you guys, here we are. We got some networking going on here, but you guys are missing out. We got some book giveaways. So let's get y'all set up. We're going to get started in a few minutes. We'll get started in just a few minutes, y'all. Let's go ahead. If you want to grab your seat, it's about time to rock and roll. All right, you guys. I know. Grab some business cards. Tell them you're calling later. We'll have lunch probably later. Maybe afterward in the parking lot, you can say hey again. Good stuff, you guys. So before I bring the guys on to come and talk, I'm gonna not forget to give away some books. Any of you guys like Malcolm Gladwell? Yeah? Okay. So I am gonna be giving these away before the end of the night. Either we can incorporate it with you guys, or I'll find out. I always have to think about like a question to ask or something. But so real quick, guys. So the topic for next Tuesday's the Real Estate Investors 101 class is the topic of building your team and treating your business like a business. With that thought in mind, y'all, what these guys are going to talk about tonight is key on two fronts. One, it's when you treat investing like a business, you need to have more tools in your tool belt, right? Because if all you're looking for is a house listed with realtors or a for sale by owner sign that is just they own it free and clear and they're going to sell it to you, you're going to struggle. I meant to count the number of deals this year that I've done that were probate succession, but I'm thinking 6 to 7, maybe even 10, like closer to the 10 number range.
All of them?
All of them? Yes, it does feel like that, but sometimes. But almost every time I deal with is there a probate succession thing? It's like I have to it's so frequent. But I think the real number is closer to 10. So it's a huge part. When I'm buying properties that are discounted, I come across this so often. My friend Adam says if all you have is a hammer, everything has to be a nail. Because if you don't have the right tools, you can't solve that problem. This is a skill set. Understanding the probate process and how to handle successions has something that has helped me as an investor. So you guys are treating yourselves like professionals and treating your investing like a business by learning about these things, right? So I want to commend you guys for that. Having, one of my favorite things is, if the only thing stopping me from doing a certain type of deal is education, then that's not going to stop me, right? I'm going to figure out how to get it done. The second thing is the topic is, treating it like a business and building your team. I work very hard to build the team of professionals around me, and I do business with Fleur de Lis, with Jared and John, to a degree now that it's. I've done business with maybe 6, 7, maybe even 8 title companies in the area, and now I do all my transactions with them. and I'm thankful to have them on my team. The goal is guys, if you're going to treat this like a business, you need to have people on your team. Bob is my CPA. I utilize him. I mean, it's one of those things where I don't want to feel like I can't trust my team, right? Like going through a transaction or whatever. You know, I had other CPAs before I met Bob. I felt like I was educating my other CPAs before I met Bob. It was one of those things where I was like, oh God, they're not going to know how to handle this one deal. Oh God. Like, how am I going to give this to him and tell him to figure it out, right? So with that being said, guys, I just want to encourage you, whether you attend next Tuesday or not, just consider ways that you can treat your investing like a business, because then it'll really pay you like a business, like it should. And on the second side of that is really be intentional with building your team. Investing is a team sport, so having people in your corner, trusted professionals, it's a really big deal. I value it a lot, all right? So we've got Jared Biguez and then John Stevens from Fleur de Lis Title. Without further ado, they're going to talk on the probate process.
All right. Just to make it clear, John's going to talk about the probate process. I'm just going to sit here.
Yeah, you finally let me talk. All right, so I'll start getting more here quick, and I do have an outline here, right, where you see it. At least it's a lot of words on paper. The succession process, particularly as it relates to immovable property, just because that's kind of the more detail-oriented part of the process from getting from point A to B. Requirements of notice, this, that, and the other, that the court applies a more scrutinized degree of oversight, right? But even as it relates to movables too, it's not a straight linear A to Z type thing with a succession a lot of times, okay? There are a lot of dynamics, there are a lot of things that will rear their heads that you don't foresee coming because you're none the wiser, right? You would not have had reason to know.
He's not lying. Almost every time I deal with a section property, it gets more complicated.
Yeah.
It just does.
Well, we've got a couple of them now.
Yeah.
And communicatively, right, it can be frustrating sometimes because, for instance, one of the properties that we're working on was in a succession, was subject to succession, and we'll talk about later why this is important. But the law firm actually that was handling it originally completed the succession, and in doing so kind of severed an option for the heirs in being able to make a private sale of property as opposed to public auction. And so, again, we'll dive into that a little bit later, but it's just kind of, it's pretty nuanced. And again, it's as easy as it might seem for me to sit down at my desk and say, okay, here's all the information, here's the roadmap, right? A lot of times you're running speed bumps, okay? So, that being said, as things come into your minds, questions, whatever experiences, whatever you have, don't hesitate to stop me and ask or comment, because that's basically the nature of the beast, okay?
And also, whenever y'all have some questions that we don't necessarily know the answers to,
yeah,
our information's in the back. So like the legal code in Louisiana is pretty big, and so we don't know all the rules off the top of our head. So if we do need to go look something up, we'll definitely do that for y'all. So bear with us, you know, if you ask us some questions, we may need to go back and refer to our materials and make sure that we have the right answer before we.
we had a professor, all right, and he knew every word of the code articles, and we used to laugh because it was like he was asleep, but he was just saying word for word all the code articles. I mean, it was the most remarkable thing. Well, he was probably like 180 years old, but
Hopefully not listening.
yeah,
He probably doesn't know
Professor. Okay, so we don't have that retention now. Again, I'm just going to kind of take this as it comes. I tried to come up or find some things that also related, obviously, specific to real estate, but some real life issues, right? Kind of horror stories that might pop up, just to kind of give you a sense of the gravity of what sometimes you might be looking at unexpectedly. Okay, so what is a succession is the first and obvious question, right? Has anyone other than Courtney had to deal with it on any level, be it professionally or personally? Right? All right, we got what we got. Do you have an answer for me? What is it? What is it? What is a succession?
It's just in that way. If there's no will, then the property has to go through
That's right. Okay, so, and you pointed out a couple good things there. All right.
Oh, you can do that. If you
Yeah.
guys want to.
It's got you a book, right?
Yeah.
Everything's over.
Okay, so
Yeah, good job, because otherwise I'll have to figure out questions.
it is when an individual passes away, it is how, it's the legal mechanism by which they transmit their estate to their heirs, whoever those heirs might be, okay? And you raised some good points as far as if there's a will, if there's not a will. We're a funny state, all right, Louisiana, we're the Napoleonic Code, right, we're the Civil Code, so ours comes from French heritage as opposed to common law, which is majorly, I think, kind of British, and it comes from Roman law for that. But succession is our word. You hear it in other states as probate. Okay, we do use the word probate, but really only when there is a will, because a will in our successions has to be probated. Okay, so just suffice it to say, anytime a person dies, if there are assets to be transferred, a succession is open. Whether or not you petition the court to probate something depends on whether or not there is a will. Okay, so to that point, when there is a will, someone is to be considered to have died testate. Okay, i.e. they're a testator. They have signed a last will and testament. All right, cool. So, which means, and we can kind of get into that a little bit, but there are two forms for wills. In order for a will to be valid in Louisiana, it has to be either handwritten and dated and signed, all in the testator's handwriting, right? Or it has to be notarial, something like Jared and I prepare, right? It's typed up. We have the proper legal clauses in there as far as the attestations, the swearing of, hey, this is my last will and testament. I'm of sound mind, disposed of memory. Okay. So there were, prior to, in the mid-1990s, there was a statutory will. So we still see those sometimes in our probate process, which we just reflect our succession pleadings accordingly. But that's all to say, testate means you at least have some sort of valid will that the court's going to look at and say, okay, this disposes of this person's assets. Okay, we're going to probate it. We're going to stamp it as valid. All right. If you die intestate, that means you have no will. So if you die without a will, it's intestate. It's at an I and an N. Okay. That occurs. The Louisiana Civil Code, Code of Civil Procedure, and revised statutes give us default rules as to what's going to happen to someone's property. Okay?
So the kids can't just say, oh, well, this is what mom would have wanted.
Right. Now.
No.
Right now.
Unfortunately.
Hence the importance of an estate plan. I'll go ahead and push that very quickly, which we also handle. But no.
Well, we laugh,
yeah.
but I've been meaning to make a will
Yeah.
for a little
We
while.
got you.
I don't know about you guys, but that's
Yeah.
one of those things that gets put on the burner. I'm like, I need to do this. I don't know, is the dog going to get all 10 of the properties? Like, what am I going to,
Right.
you know, the joke. But it's
People
for us because we have assets, right? It's something for us to think about. So if you have assets and you're not thinking about wills and stuff, what's going to stop, like if a bus hits you, what's going to happen to your properties, your rentals, your
I was
the
about to
flip
say.
you own, you know,
Yeah.
your businesses.
And Frank, it's not only if you own things personally, but because you're dealing with businesses that deal with transmission of real estate, right? Obviously, those assets would be titled in a lot of senses, I'm sure, to the actual business, so it's not your personal asset. So it doesn't necessarily move or transmit in accordance with your personal will, right? It's an LLC particularly, right? It's assets in the name of an LLC or the LLC's assets. So really what you want is an operating agreement for your LLC and things like that. So that's all part of it's things that could actually arise in succession, right? So something to be aware of. And hence, see, you can see me now that I'm telling you it's not okay. Anything you need?
I'm going to throw in some practical points for the closings that I had, but I'm going to look at them.
Okay, all right. So, the right, so we're talking about if you have a will, it needs to be probated, okay? From, if I were to go open, say if someone passed away, okay, so my family member, and maybe I'd take charge and opening in succession, talking to an attorney, getting it open. You know, I'm unaware that a will exists after due diligence, right? I can't find it. Any individual, you have 5 years from the opening and succession to offer a will for probate. Okay, the law kind of protects heirs and also third parties who might purchase assets from heirs, they say, okay, 5 years is plenty of time for you to have found a will and have it probated, okay? So that's from the opening of the succession, all right? Now, have there been instances perhaps when you have to make the argument, right? So say I don't want them, 6 years pass and someone tries to come and say, oh, hey, we found this will, we want to probate it. And it's, to me, if I'm in charge of the estate and it doesn't seem to benefit the estate, or the court doesn't think it's going to benefit the estate to do that, maybe we've already alienated assets, this, that, and the other, then they're probably not going to allow to come in. But if everyone's on the same page, there are extenuating circumstances where the court would be okay with that. But the big rule is 5 years from opening succession, you need to make sure you have your will. In y'all's industry, you want to, in our industry, frankly, if we're doing an abstract and we see that succession was open and it was open as intestate for whatever reason, 5 years pass before it closes, and maybe a piece of property is sold during that succession process, and then we see a will being probated 6 years after it's open, that's going to raise a red flag for us. We just got to kind of dig into it a little bit more.
So
Yeah.
quick question with that. So let's say grandma died, sadly, 2 years ago, and I'm at the doorstep wanting to buy the property, but there was no will, and so they open up succession, and let's say I go through and I buy the property. Could they come back in 5 years and maybe reverse the sale because they found a will that said, oh, that house was supposed to go to Johnny?
Possibly, if it's done, yeah, the prescriptive period is 5 years. Now, again, then you're kind of looking at, okay, what is the basis for rescinding the sale? What happened to the proceeds from the sale? Were those distributed accordingly and fairly, right? Is it going to serve the best interests of the estate to rescind the sale for some reason?
Right.
Right, and then I could foresee arguments there, obviously. And this is all to say, you can open a succession well after 5 years after someone passes away, right? That we see that all the time. Some people, we have to open 2 generations worth in order to get a property sold because...
One of the ones I'm dealing with right now, I don't know when the guy passed away, but I'm thinking it's more than 10 years ago.
Oh, yeah.
And the kids are like, we just wanted to leave it like Dad had it. I'm like...
Yeah, it's a little more to it than that.
Yes.
This is why you buy title insurance.
This is a big reason, for title insurance. I mean, just because people coming out of the woodworks, but I mean, you're not going to be able to get to that policy if there's not clear title, right? As far as, okay, if we have a common ancestor 2 generations ago and those successions haven't been open, we go back in as a part of the blood.
He's probably referring to whenever if somebody came back and tried to probate a will after the property
Yes.
alienated, your title insurance.
My title insurance when you guys close on it.
Yes.
So that helps
Yeah.
protect me, right?
It is a ounce of prevention worth a pound of cure, undoubtedly.
No, huge. You should be buying it every single time.
Okay, so testate successions, right? We have a will. Generally speaking, it gives us the testator's intent as to how he wants his things to be disposed of. All right. One of the things we put, and we advise our clients to put into the will, and it makes things just easier, obviously, is you designate your executor, okay, which is basically your point guard, the person who you trust to, when you're gone, just be the spearhead of the succession, right? And most of the time that means, hey, I'm going to work with the attorney, right, to make sure I do what I need to do. But it could be executing documents. They have the authority on behalf of the estate to act, right? So you want to name someone you trust, obviously. This person has a fiduciary duty to the estate to make sure that, again, it's handled and administered to the greatest benefit of the estate. Okay.
To ask a question, you're talking between, testate and intestate. People who have wills and people who don't have wills. Oftentimes, when you're dealing with these successions, how often do people have wills? Do they more than often not have a will, or do they more than often do? Like, what is your experience been?
I've seen about 50-50 when I've dealt with them as part of a real estate transaction. The benefit of somebody having a will in place with an executor, namely somebody who can act on behalf of the estate, is that practically speaking, as a title attorney, when I'm trying to coordinate the sale, I would rather have one person come to represent the estate than 6 heirs having to come. So what we'll do is open the succession, part of the closing process, and we'll coordinate with the executor saying, look, instead of transferring interest in this property to 6 heirs, leave the estate as the owner of the property. The estate will sell the property. We will then take the cash from the transaction and give it back to the estate, go into the estate's bank account, and then the estate can distribute the funds between the 6 people. And that way, they only have to have the executor of the estate come and sign it for them. Makes it much easier for us. And generally, you know, the chances of somebody dying in Slidell and all 18 of their children living in Slidell, very small. Usually they're, somebody's in
All
California,
over.
somebody's in, you know, overseas somewhere, we have to coordinate, and it just gets complicated. So if we can help it, that's how we like to handle transactions.
What do you do if you can't get in touch with someone who cares?
So,
That's the fun part.
it depends.
It depends. So if
on
the
a lot.
estate hasn't been opened and closed, then we will always try to have the executor act on behalf of those heirs and then let them deal with it. If the estate's been opened and closed and and there's just 6 co-owners as siblings or cousins that own it, we really can't do anything. I've had 2 transactions in the same month happen where 50% interest was transferred to somebody that was coming and selling the property, thinking that they owned the whole thing. Well, actually, they had inherited from a grandparent, and the other 50% was floating around with people who were, like, had actually passed on to aunts and uncles of that person who was trying to sell, and some of them had died. So they're
So it then becomes a big web of this person died, now it's all their 5 children,
Yeah, so it's-
they own certain
Yeah,
percentages.
20 people.
And so as an investor, whenever you get that type of transaction, it could be very beneficial and you could get, it could be a great deal for y'all. Obviously the numbers work, but from our standpoint, it's very difficult for us to corral all of those people to come to the closing. So,
You have options.
well,
It's
Courtney
just
does-
more
Courtney
difficult.
does a great job with this. She presents information to us and she usually does a lot of legwork before she comes to our office with a purchase agreement. So she'll come to us and say, here's the addresses and phone numbers of all these people, and they're all available on this day at this time to be at your office. Like, not many people will do that for us. Usually it's like, hey, there's 20 people out here, go see if you can find them, and it's just, most times it's impossible to do. So it gets complicated.
Yeah.
So executors are important. That's, we tie it all back together.
One of the things I will say though, when there's many, typically they're adults. Every now and then you're gonna come across with minors. When's the last time you got 2 adults who can come to an agreement, right? Like that's just the running joke with them. It's like, but then try having 6 adults and there's money on the line. And so greed flares up. I've gotten into the middle of some family sticky business during successions, and so for me, there is an opportunity to make money there. It's just willing to what degree. This is kind of like you have to decide as an investor: are you willing to participate in something like this, and to what degree?
Yeah.
Right? Do you want to specialize in it? Do you want to deal with it from time to time? Do you have a cutoff limit? What do you do? If you come across something that's difficult, send it my way. I like working with the complicated stuff.
And then
Keep going.
their title attorney says,
A question about if you can't, so you can't find one of the heirs to the property, what do you do then? Can you do like a buy title?
So, it depends on if it's testator and intestate, it depends. One of the things you can do, sometimes the court will have you appoint a curator to represent the absent heir's interests, okay? Depending on whether, okay, so, not to get too far ahead, but certain notices may have to be published, right, in certain parish where the removal is and parish where the succession is taking place. Okay, so there are due diligence parameters, right, that are prescribed for trying to handle that situation, but it doesn't necessarily render everything super easy. Now, there are other ways, depending on the value of the property, it can be a lot easier. And I'll get to that in a second, but so I will answer that for you. And we're talking about this in the respect or with the understanding of what the executor does, right? And we know that the executor comes from testate succession because the executor is named in a will. Okay, so you want to a lot of times what we encourage is what's called an independent administration, which you have to provide for in your will. Okay, it's not a default rule, and that allows your executor to administer the estate without nearly as much oversight from the court. They don't have to publish a notice requirements, it saves you money and saves you time, basically, or saves the estate time and money, okay? Because it says, hey, I'm naming someone who I can trust, and I'm gonna allow them to independently take care of this stuff, so that we're not going back to the court for every decision and having to get their approval for every decision. So that will alleviate some of the notice requirements if you can't find heirs, right? Not to say that that's a absolute cure for that, but again, that's just for what it's worth. Independent administration, something we would certainly look for. Hey, if it's not an independent administration designated in the will, then did all the heirs provide a verification saying that they're okay with it being independent? Okay, minus that, then we're saying, okay, well, we're going to need to see some court orders allowing certain sales of property, right? Okay.
And so you're talking about an heir that can't be found, right? A contentious heir that doesn't want to come and sign, we'll talk about that, just remind me to bring that up. And we'll talk about that later.
All right, so if it's not independent, it's going to be just a regular administration, right? Again, that's when you would have to petition the court to sell property, be it through a private sale or a public sale. Okay, so that's when you have to make certain notices in the newspaper. You have to make notices in the parish where the succession's taking place, which is going to be where that person was domiciled at the time of the passing. And then if the property is in another parish, you have to publish there as well. Okay, sometimes you have to do it twice for a private. So for a private sale of administered succession, you have to publish it a couple times. I don't expect y'all to remember all this, right? But it just, in the timeliness changes depending on the dynamic of the succession. But suffice it to say, having an independent versus a regular administrative succession, you can see already where, hey, you don't get hung up on a lot of the things that are required if it's an independent administration.
So as a buyer or as an investor dealing in these transactions, hearing us talk about time delays and things that have to happen, you will be able to help the client understand a little bit more now that after you hear these things, why things are taking longer or more or less time in a real estate transaction.
Right.
Independent administration, y'all, we're dealing with all these things, but that's going to go a lot quicker because we already have the person in place that can actually administer the estate. Somebody, a non-independent administration takes time. So we have to deal with a lot of those things. And I'll talk about logistically how we handle closings at Fleur de Lis title successions, and but after John gets to a certain point. So.
Cool. Okay, so then we're talking about basically what you would call a normal succession at this point, right? Okay, be it testate or intestate. Okay. We have in Louisiana what's called a small succession. So if the property that the person dies possessing is less than $125,000, you can opt to use a small succession as opposed to regular succession. And there's even an option to basically forego going to the court, okay, and filing the petitions with the court, and you can just instead use an affidavit that you lodge in the land records of the parish where the property sits. But in order to do that, the person who had passed away, obviously the property cannot exceed $125,000. They either die intestate in Louisiana, so they're Louisiana domiciliary and they don't have a will, okay, or they are out of state, okay, they do have a will and it's probated in that state, okay, so we would then be handling the ancillary probate. So if it's Texas, I feel like we always get them from Texas. Texas attorney will call me up, hey, we need it, there's property, the person died, they live in Texas, there's Louisiana property. Send us over, okay, we say, okay, send us over a certified copy of y'all's orders and a copy of the will from Texas that the court has stamped. We file that with the death certificate and our affidavit and the land records, and that suffices. That's all that needs to happen, okay, for that piece of property. That kind of harkens back to what you asked, hey, what if there's someone you can't get in touch with? Okay, so on affidavit small sessions, I've had to do this a couple times, a lot of heirs, some all over the place, one's like in Alaska. You can send certified notice of your intent to transfer the property, okay, or file the affidavit, and they have 10 days from the receipt of that to submit written opposition or objection. If they don't, you can move forward with it, okay. Also on a small succession, just for what it's worth, because it might be salient for y'all just because, you might see something go on the market, oh, this is subject to succession, right? Oh, it's under 125,000, oh, you could do this really quickly, transfer possession to the heirs and then I can buy it. You have to wait at least 90 days from when that person dies to file an affidavit of small succession, which is kind of a protective thing for maybe heirs who, aren't around, right, to get notice or to get word of what's going on.
That, small succession, that under 125,000, is that for all the assets? Is that like a collective of all the assets that they
Part of
own?
the estate has to be-
Yeah.
So those are
The
any
estate in
cars?
Louisiana.
So is that like cars, bank accounts, you know, money market stuff, stocks,
Yeah.
houses, all of it under?
Well, the value of property in Louisiana, so when you're bringing in all the other stuff, if they're domiciled out of state, okay, they're gonna handle that, like in, let's say Texas, all the money market, all those intangibles, things like that, okay? Let's say the person dies in Texas with, you know, an IRA with a $200,000 in it and a money market account with $500,000 in it, right? But then a piece of property in Louisiana for $124,000, file the affidavit of small succession in Louisiana.
Okay.
Texas court handles the rest of this stuff. Okay, so it's property situated in Louisiana.
Put you on the spot.
Yeah.
So
What's
that
that?
all the estate is worth, say that the movable property is worth $200,000 with a $80,000 mortgage on the property.
All right, yeah, I know,
So
so.
will the value of that estate be 120, or we had this conversation and we
Yeah.
were supposed to look it up,
And
but I don't
there-
know if you didn't know.
But here's the deal, because that, and I have gone much further, because that poses a really good question, okay? And I cannot answer that, and here's why. So sometimes,
Well, quick, Jeff LaShare
Okay.
said, great job.
Okay, look,
Yeah.
so because he's listening right now, this is not legal advice. If
Oh,
you
yeah.
want legal advice, please call
Yeah.
your attorney.
yeah, none of this is typically. So.
That's the other Fleur de Lis, that's
Yeah,
their
that's
Fleur de
our
Lis.
fault.
Yeah.
Sometimes, an executor, and this is kind of getting in the weeds of things, but may have to post security, okay? Which means they have to put up a certain amount or fraction of the value of the estate, right? And you can do that in multiple ways. You can do that basically kind of by an insurance policy. Some people offer, some companies offer them. You can, it's basically like posting a bond in a way, right?
And what's the purpose of that?
Just to protect the heirs, to make sure that the executors are adhering to their fiduciary duty, otherwise they lose this what they put up, okay?
So if the executor acts in bad faith against the estate,
Like earnest money deposit.
yeah, that
Yeah.
insurance policy will then protect the estate in the case that they can prove that he was actually acting in bad faith.
And then there's also, I'm gonna get you, for other people who might be, come up in a succession called a usufruct, and we're not gonna get in on that, or usufructuary, if they inherit the usufruct over something and naked owners, and we'll talk kind of about who that are children, not of the marriage, okay, but of like their second wife, they can require that person to put up security, and we run into these issues. And and there's no clear answer as to whether or not the debt, the liability against a piece of property is to be considered in how much they have to put up in security, in determining security. In fact, as much, I love doing legal research, and I've looked into that like crazy, and really it honestly points towards no, the fair market value of the property. Now, if the other parties are agreeable to allowing the liability to knock that out, then you can do it that way, right? As long as everyone's in agreement and you lodge the certain recordings or whatever have you as far as security goes. But it's a good question, not a super easy answer.
Can you get back to me on that?
Yeah, I'll get back to you, buddy. But I would say this, if you have a $500,000 piece of property here, but your outstanding note on it is $376, I don't think you can file that affidavit, because you're looking at the active mass, because when you file, if you have that, because you also have to set up your sworn detailed descriptive list, so when someone dies, part of the succession process is you have to provide the court with a snapshot of that person's assets at the time they died, all these things we've been talking about, money market accounts, property, this, that, the other, the liabilities against those, right? And so you have your total fair market valuation and your total liabilities, and you have your recapitulation of, hey, this is the net. So because you have to do that, I would venture to say that I wouldn't try to mess with that today. It's a good question.
So the whole point that we're questioning that is the affidavit part seems to be kind of like a shortcut.
It's quick. Oh,
It's
yeah.
a quick shortcut because how many times have you guys said, hey, okay, you kind of want to buy a property in like a week? You're like, hey, I can buy this, cash. I'll close in a week or 2 weeks. Well, if you're dealing with a succession property, you can't guarantee that.
Right.
Well, and it could apply in this situation, right? The property is owned by husband and wife, property's worth, $200,000, and the property's going through foreclosure because the surviving spouse hasn't paid the mortgage. We have to do a succession, and we could do a small succession in that instance to transfer ownership because the decedent spouse interest, half the property is worth less than $125,000.
You bring this up, but there's literally been 2 in St. Tammany Parish within the last, say, month that were facing foreclosure, who I knew when I looked it up that one of the party listed was deceased, and it was an unopened succession. And so it's like, they're saying this, but this is real life going on in our market.
Yeah. All right, now, and I do have a clear answer for it, because here's the deal. If you have that outstanding mortgage with that much, right, then they're a significant creditor of the estate, and it has to be filed, and it has to be administered, so that creditor is gonna be paid, right? Because if they're gonna, the people cannot inherit through an affidavit of small succession, because then there's really, it doesn't really confer or extend liability to them for that note, and they have to inherit subject to the liabilities and debts, right? So, no, couldn't use an affidavit for that property.
Can't use a shortcut, dang it.
Yeah, not for that. Now, if it's owned out right away, and it is less than that, right, or even if it's less than that with a note on it, you still, so, I would still probably say you just use a small succession, so you can use the affidavit for small successions, right, property's value that, but you can still do a judicial opening on a small succession, right, which is going to the court, it costs less. So even if you're at $125,000 or less, right, in valuation of property, you can go to the court, because you might need to pay off your creditors and make sure that your judgment of possession protects their liens and things like that, because the last thing you want is to get foreclosed on out of the blue.
Yeah.
Does that affect the contract though? Like-
Shoot, sorry.
So,
Yeah.
so like the sales contract, right? So
Yeah.
I wrote a contract today on a succession. Should I have put a larger time frame, or is that in the standard real estate contract?
How
too?
much is the value?
It's $117,000.
So you want to ask the question, when did the person die, basically?
Okay.
It's
It's been on the market for over 90 days.
okay, and that kind of raises a point.
It's in
Sometimes.
Mississippi too.
Well, this
Okay,
is
then I don't-
Louisiana.
Yeah, that had zero. Yeah.
But just in general,
Hypothetical.
how would I want to address that? If I'm making my own contract, or is
So-
it in a real estate contract?
You can maybe put a suspensive condition on it, I guess. And then-
I would give yourself more. I mean, and I'm no attorney, but I would give myself more time if I know I'm dealing with something, and I would say that with the sellers. Hey, obviously there's title issues. Let's give ourselves more time.
I would say that, yeah, right. I would say that if you're in that situation, judicially open the small succession as opposed to using the affidavit, because you can judicially open the succession before 90 days. You just can't use the affidavit before 90
And then you
days.
sell it through the succession.
Yeah.
And let the.
It's always best to sell it through the succession than outside of the succession.
Not necessarily.
Not necessarily?
Not necessarily, but I was going to bring that up earlier. When it's convoluted, yes, undoubtedly, when there's a bunch of people you might be dealing with, but a lot of times we'll push it through just because if a sale comes up, or you know it's pending, yeah, go ahead and knock it out. But sometimes we'll push it through if there's just, an error that you're not going to really have to worry about, maybe twos that people are happy to come sign, just because it could save you money in the succession. Insofar as, we don't have to, depending on how the attorney might be billing you, right?
The paperwork that has to be done on our end is a lot less if we open and close the succession than opening and selling it through the succession.
Yeah, so.
Right, because of the bank account stuff and all that. Yeah.
Appointing the executive, letters of testimony issued, things like that. I mean, is it a ton of money? Maybe not necessarily, but again, sometimes there are times, hey, let's push it, we'll get the judgment possession filed really quickly, and then you file the deed there, subsequently to that really quickly. Okay, all right, I'm ready.
About timing, or do you want, should I go into?
Go for it, you start talking about time.
Okay, so whenever, if, and this is logistically speaking, when Fleur de Lis title handles a transaction with a succession involved, we will generally do both things at the same time. What I mean by that is that if you go to a third-party attorney who does like estate planning and successions as their primary focus, and they don't do real estate transactions, their process is gonna take a little bit longer because they probably have other things that they're working on, they're not focused on that. But we have a closing coming up Tuesday that we got last week that has a succession involved with it. And so we have a processing team that handles the logistics of our file on the back end. John and I do the legal work that pertains to the file, so we know that this property has a succession. John and I are gonna focus on getting this succession done between the day that we get that contract and the day that the file is being closed. While a law firm as Fleur de Lis title, we will move along the process knowing that the succession is gonna be finished because we're handling it internally. While if we have a file that has a succession needs to be done and a third party attorney is handling that succession, we want to make sure that they do everything they need to do beginning to end and then get us the paperwork so that we know it's finished before we will actually even move forward to get towards the closing. The process takes longer. So if you know a property is going through a succession and it needs to be open before the closing can take place, whether it's us that handles it or another title company, you might want to ask that title company, hey, do y'all do succession work in-house so that y'all can move the process along faster? Because being in control, we'll be more comfortable moving forward.
Yeah.
How do we see if a succession has been opened?
Courtney.
So, clerk of court, if you don't understand how to use the clerk of court, which is the like archive division of public records, right? When people say public records, when they say archives, I know you should know in the parish and the markets that you're working at, like when I say I play and I swim and I live in public record, it's because so much of the stuff that's recorded publicly affects the properties, like if they have a mortgage, if they have liens, if they have, whatever. And so by understanding how to use public record, you can understand this stuff. For example, you can physically go to locations in St. Tammany Parish and go to the clerk of court there and look up a property and see if there has been a judgment of I always look for a judgment of possession filed, and you can see because it names, it'll say the person's name and like usually deceased behind it, and it'll name like all the kids or one of the kids, whatever. You'll start seeing like that. The judgment of possession will actually, it's like recorded. I'll get to see, and like it'll name like Capital One account number, like whatever. It'll say, money market, Edward Jones this, whatever. It'll say 1987 Chevy truck, and then it'll say the real estate stuff. Like, so it'll list all the assets in it. And so I look at that stuff. Now, if I know they say Mama died and Mama owned the property, and I don't see that, it's going to be a red flag for me. I'm going to be thinking maybe they don't have a succession. Does that make sense? There's ways that you can look up public record online and see in person. It just varies by parish. And so if you're working in a market, you should know what that stuff looks like. It really, really expands your toolbox when you can do that. But I know it's not for everyone because everyone's like, oh, that's paperwork and research. It really can change the game for you if you understand that.
So we obviously have access to all the first records online. So if you have a property that y'all are looking for information on, generally we will go and do a search for you just to see what we can see. Obviously, it's not an official title review, but Courtney several times will come and say, hey, can we look at this property? And I can do that for y'all. So if y'all have any questions about that, obviously, if you abuse it, I'm going to stop answering your phone calls whenever you're calling about that kind of stuff. But like, if you have one or two properties that you want to see some information on, just let me know and I can pull that stuff. Second thing, if you go to the assessor's website, it's going to tell you who the owner of the property is. It's also going to say
That's a great point.
who's in care of the property, and that sometimes will indicate that if John Stevens is owner of the property, but it's care of Jared Miguez, it could indicate that for some reason he's not managing his property and paying his taxes. I am, and you can maybe insinuate that if somebody said that their family member died, and you look on the assessor's website and it says that it's in care of somebody else, you could kind of ascertain that that person might have passed away. And then it's kind of morbid, but I'll go on legacy.com and it's obituaries, and you can search somebody's name and it will literally pull obituaries up for people and tell you children they've had, things like that. You want to go get some more information.
One of the good things about the assessor's site is, and I'm speaking for St. Tammany Parish, but if you don't know how to work your own assessor's website, for whatever parish you're dealing in or whatever, you should go online and play with it, right? Look up your own personal house or where you're renting from and say, oh, who owns this or whatever. Go and look at that. But so St. Tammany Parish, it'll say, like for example, it'll say my name, it'll say the physical address of my property, the mailing address, so then you'll know, if they're different, are they the same? And then it'll say the legal address, and it'll include some instrument numbers, which those are public record indicators of like, these are the public records. If you ever see in that legal description something that says half interest or half INT John Morris, and then 1/4 John Morris Jr., whatever. If you start seeing stuff like that, then in my mind, a succession has been done because they've already divvied up percentages. So that, if you see maybe the word usufruct, I know we mentioned that earlier, not to dive into that, that's a red flag. A succession for me has been done. So those are some things that just by knowing how to use the assessor's site, speaking for St. Tammany for sure, you could see stuff like that and kind of see.
Yeah.
But
to answer your question, generally, I would say a free source would be the assessor's website, just to get some information on the property. Second would be leverage your title attorneys for the clerk's website. So if you pull up an assessment and say this property, it has, you look and you see some people who might have interest in this property and you want to know about it, just email us, hey, can you take a look at this property? We'll just pull it up, do a quick search and let you know if a succession's been open on that property or not.
And also utilize the seller. Be like, because, okay, for example, I walked a property earlier today in Slidell, and I asked the gentleman, I said, sir, are you the only person who owns this property? I already knew that wasn't the case, but I wanted to address the elephant in the room. He said, no, my brother also owns the property. I said, okay, is he in the picture? Who is he? So anytime, if you're dealing with a realtor, you should have a competent realtor who is also doing this. But if you're dealing directly with, say, a for sale by owner or whatever, you want to know who all owns the property. Are they alive? Do they live here in the area? Are they happy about selling? Are they open to selling? Because if not, you're getting into a whole lot of complicated stuff where they start talking about, oh, someone lives in Alaska, or they're not interested in selling. Like, you need to know these because it's going to affect you being able to buy the property, right?
And I do this for some people too, some of my clients. If you ever want to come and run by our office and schedule like 30 minutes for us to show you how to do these things, I have no problem doing that. Just have to make sure that you call and schedule and just don't show up at the office. So I might not be there, or might be in the middle of doing something else. That's right.
All right, so.
We got about 15 more.
Okay. I talked about earlier, it was kind of a good question because we said, is it best to always sell this property within the succession or not? And just kind of made me think about it. Earlier I said, depending on how you handle it, or if you had an issue with one of the properties, right? The attorneys that were handling it, and they didn't necessarily do the wrong thing, but maybe they just didn't see exactly what we were trying to accomplish now.
It cut out an option for us.
Cut out an option. So,
that would be really helpful right
let's
now.
say you have 4 people inheriting a piece of property, okay? And there's no executor right necessarily, so there's got to be some court oversight here, okay? Even without court oversight, if they don't agree, they can argue in court, so the administration doesn't. So regardless, say you have 4 different people inheriting a piece of property, 3 of them want to sell it to this person because they think it's a good deal. One of them's just holding back. It's like, no, I don't want to do that, right? Okay. Outside of the circumstances of a succession, let's talk about just normal ownership. Okay. 4 people, me and Jared own the same piece of property. I want to sell it. He doesn't. What do? We partition. Okay. So we either agree, we partition by private sale. We find one and we sell it, or it goes to public auction. Okay. All right. Within a succession, you have the 3 people who want to sell, you have the one who wants to hold out. Okay. A lot of times, when it's not within a succession, and you push it all the way through, the judgment of possession has been rendered, and now you've got 4 co-owners. If that one person doesn't agree to sell it to the person you pick for your private sale, then you cannot, a lot of times it's difficult to get a court to order them to sell it privately. The court's gonna say, no, we gotta bring it to public auction, okay? Say you're in Courtney's position, all right? And there's a piece of property that looks like a good buy for you, all right? And you've got three heirs in succession who want to sell it to you, but there's one who's just holding out for whatever reason, okay? Within a succession, you are far more likely to get a court to actually order a private sale if it's in the best interest of the succession, okay? So if you push it through and you close the succession and then you just end up with multiple co-owners, you significantly decrease your chance of being able to get that property that you might want, and you really have to come up with creative leverage like we're trying to do right now. So
I've been trying to buy this house for a year, y'all.
yeah.
So the best case scenario is to try to have the heirs force the partition to the court and then transfer ownership to you, as opposed to wrapping up the succession, transferring interest to the four owners of the property, and then trying to, and you always also could acquire the three siblings that are agreeing to sell as interest, and you have a 25% outstanding interest, and now you are co-owners with that person.
That's
And then you can force partition, which is another way to do it. If those three heirs just want to get out of the picture, you might be able to get a discounted price from those three people to buy position in the partition. But
That's more advanced. That's more advanced stuff where you're like,
what I mentioned earlier, when we a contentious heir.
Yeah.
That's what.
Do you want to co-own a piece of property with that guy?
Yeah.
Right, first of all.
which we've done. We've done transactions.
Yeah, right. I mean, it's
Right.
you know, you can be a problem child. So anyway, so that backs up to as far as see. You want to make sure you see and kind of understand the objective, right? Look at it full picture before you do anything hastily. Again, I'm not saying that firm did anything hastily. I think it was just a miscommunication as to what the options were. They just kind of cut it off.
So that firm transferred ownership to the heirs?
They completed the succession and then filed the suit to partition. So now it's the middle of the partition, and furthermore, they didn't add. So if you ever need a partition piece of property, say you own it with somebody else, or whatever, if you're looking in trying to buy it, okay. Regardless, if you're one of the co-owners, you want to put in your petition to partition that by public sale a minimum price. Okay, some courts have said if they don't see it in there, they'll sell it for what it goes for, and it could be, you could lose pretty good on it, right? So you always want to at least put that in there to protect yourself. They didn't do that, so we got to go back and amend it.
How does a succession close if there are still things that need to be transferred?
So it doesn't close until everything's transferred. If let's say something was missed, you just go back. You have to amend the judgment of possession and file a petition to amend, right? And state why for good cause. The court can reopen the succession for good cause check. Okay, there's no super black and white list as to what that is, right? You just have to look at jurisprudence and see if it's something that makes sense. Finding obviously succession property.
Yeah, we're doing a succession with a movable property we're trying to sell. We have other assets. We're going to do the whole succession.
Yeah.
And generally, we'll close the succession unless the executor wants to continue moving forward. That it honestly never had to deal with that where we had to continue administrating the estate afterwards.
So,
But John has, and
Yeah.
so that would be something that we would do in house. I would just get to the real estate transaction and finish it, and let him finish the rest of it.
he's the pretty face. I'm the grunt. No, I'm just kidding. Okay, he's also a grunt. Community property laws is something to look out for. Okay, we're one of 9 states that deals with community property, so that means automatically, unless you have a prenup or a postnup, everything you acquire during your marriage is community property, unless it's inherited. If you inherit something or something's donated to you individually, that's your separate property. So you just kind of want to be on the lookout because the law treats community property obviously a different way as far as the succession goes, right? So if I die right now, my wife is entitled to outright 1/2 of everything that we acquired while we were married. Okay, she gets that 1/2 automatically in full ownership. Okay, now depending on whether or not I have a will, what that will says will depend on what happens to the other 1/2. Okay, she would be upset if I probably didn't disclaim that it would go to her, but sometimes it doesn't, right? Or if there is no will, the person dies intestate. 1/2 goes to the surviving spouse, the surviving spouse then gets usufruct over the other half, and the heirs are the other heirs are naked owners. That's kind of getting in the weed of things, but that could come into play because sometimes we've had to get usufruct and naked owner signatures on closing docs and things like that, transfer docs, because they would have to acquiesce and sell as well. So just dynamics to look for. Let's see. All right, one thing that I put this in here because we recently had an issue come through. So a seller signed the purchase agreement saying, thinking that she owned it, right? Owned the property. It's kind of outright, I guess. It was actually, after we looked into it, it had been transferred into a trust of which she was a trustee. And she just signed her.
Further clarification.
Yeah.
The property was owned by her and her husband. Her husband had passed away. Before her husband passed away, they both transferred their interest into a trust, and they were both trustees managing the affairs of that trust. So, husband and wife own property as co-owners, and as a married couple, they both transferred their interest into a trust. Husband passed away. She came to the table thinking with the purchase agreement thinking that she owned it, so she signed it as an individual person and not on behalf of the trust.
Yeah. So, and that was kind of a big, because then we had to deal with an attorney who's like, for some reason, or whatever reason it might be, arguing, hey, look, she didn't sign it as a trustee, okay? So she didn't really have the authority to execute this purchase agreement. And had they been willing, for whatever reason, to want to push that argument, then we would have had to say, okay, well, then you're going to get sued for a specific performance, right, breach of the contract, and then that just turned into a litigation that no one really wants to deal with.
And so the point that he's making is that whenever you're drafting a purchase agreement and you're signing on your behalf or on behalf, or if you're an agent and your client is not an individual, you want to make sure that they are signing the purchase agreement
In their capacity?
their capacity as a member of an LLC or the trustee of a trust. And what I mean by that,
Or if they own it as the person.
So that's why, like, whenever, because I own an LLC, I do manager of deep roots, whichever
So if you're an
LLC it
if
is.
you're an LLC buying property, right, and you're signing a purchase agreement, you want it to say, the way I would draft it is the same way you would see on the signature block for a deed. I would sign it as Deep Roots Investments by Courtney Fricke, member, and then sign. So like in the print section, you write that language out and sign it. So now you're signing on behalf, in your capacity as a member of the LLC, and not as your individual capacity. Same thing from the trust situation we dealt with. She signed it as her personal name. Well, the attorney was going to come and argue. So the full dynamic was the son of this deceased man and mother didn't want to sell, but she wanted to sell. So the son tried to get in her head and say, oh, we should back out. Well, she was going to back out of the transaction. Normal, in the real estate world, we don't normally see people signing their capacity in the purchase agreement. So he was saying, well, she didn't have authority to sign in that capacity, so technically the contract is invalid. Arguable, but if she would have signed it, her name as trustee of this estate, that would have been her, as this trust, that would have been her legal capacity as a trustee, and then it would have been a binding agreement, no arguments to be made. So when you're signing things on behalf of your LLCs, or you're signing a document, when you're drafting it, and it's on behalf of somebody who's in a capacity, not as an individual, make sure you put that in the right terms, so it can't be challenged later for whatever reason.
Yeah. Shoot.
Well, and so that comes up on that title search, right? So like whenever you go to close or whenever you do it, like you would know that it was in a trust, right? And so at what point did he want to argue it? Because couldn't she just resign a new purchase agreement as a trust?
Yeah, well, she could have, but she wasn't gonna try to.
He had to kind of talk her out.
She was trying to back out of the transaction. Because her son didn't want her to sign.
Okay, gotcha.
Yeah. So
Well,
she signed
and it goes back to understanding, talking with the seller and saying, who owns this property? And then the tax assessor would say, if it's owned in a trust, typically, I own a property in a trust. And it says, I think Oakcrest Revocable Trust is what it's called or something like that. And it to the care of Courtney Fricke or a company or whatever, I forget how it's outlined. By doing your due diligence, looking on the tax assessor's site, stuff like that, you'll see it. So for you, you shouldn't just say, oh, stuff I don't know about, you should in your mind say, I should ask about this and consult the guy on my team who understands this more than me, right? And saying, hey, don't just let this stuff bypass if it's owned by a trust or whatever. You want to make sure if you see all these names, you should be like, okay, I should be asking about all these names. Who are these people and why are they associated with this house, right? So it comes with these conversations. It then, I don't know about you guys, I'm not going to ask this question because it's personal, but how about, like, we know family drama happens in life, right? It happens in real estate too. So I can't tell you how many times, you know, I'm like, hey, who owns this house? And they're like, well, I don't want to talk about it because I'm not talking to that family member. Or it becomes this whole big dynamic. All these things that they're talking about is, that's when life factor comes into play. And so then you have, you know, the sister who, I mean, Jared and I have both been cussed out by family members of properties I've been trying to buy.
I think you talked to that person.
The 3%, the 3% lady.
Yeah.
I don't know. Then she got her son cussing, threatening me. I'm like, don't threaten an attorney.
Yeah.
Anyway, so dealing with these properties, there's a lot of hurdles you can come into play with. Understand that, yes, you can find really great deals. I have wholesaled many, and I have bought properties that are in successions. There are great deals to be found. I like them as a source, but understand it then just adds another layer of complication. Just, if you take away many things, understand that that's probably a really big point to take away as well.
This might be something that y'all would just do. So say there's a property that I want to buy and I look at the tax assessor's site and there's one person under it. So that just means that one person's paying the taxes, not necessarily who's on title. So then how do I?
It should tell you, it should.
To a degree.
It's not always accurate.
Right.
Yeah, well, this is a specific property I'm talking about. And he's the only one that's been paying the taxes for 20 years, but he only owns a portion of it and the other heirs are nowhere.
So,
Yeah.
you might look on the, whatever last deed or whatever, title transferring instruments filed should have a tax notice on it.
Well, so there was an issue at one point, especially in Orleans Parish, where the assessor was only putting one person's name on the assessment information. And the reason why that was an issue was tax sale notice was going out to only the person that was listed on there. So if somebody didn't pay their taxes, and then tax was going to go for tax sale, only one person was given notice whenever it could have been several owners that weren't listed on the assessor's website. And so, like John said, certain notice has to be given to people. I'll leave it at that. But I think nowadays, because of the tax sale issue that has happened, the assessors are having a lot more clear and complete picture on the assessor's website of who owns it. But 20 years ago, it might not have been updated. So like, if John and I own a piece of property now together and we bought it this year, the assessors more than likely have both our names listed on there. But if something was done 20 years ago and it's been carried forward over so long, it might not have had a chance to update. They might not have gone back and edited that one, as opposed to when they update, when they transfer ownership and they redo the whole the page for that property, they're going to put both our names. But if you have that property, email the name of the owner and the property address, and I can tell you who. Just send me a quick email.
Then that's also what you were talking about is clerk of court, public records.
Right.
There's
figure
due
out
diligence you go do for yourself,
where-
yeah.
Yeah, like.
And to a certain
This is
extent,
also a succession where the.
If there's stuff filed, you
Portion
can
of
say.
person, that person died, and then both people died, so
Yeah.
there's a lot of
There's
unknowns.
times in a dozen people.
And that's where
That's a-
I play with I play with like public record, I play with obituaries, I play with all those sites where you can search for people's names. I play in Facebook land with it. Like I'm like trying to track down, like I have this one property that's an unopened estate, 4th Street. And I'm like, I think I have the genealogy of the family tree like mapped out, but every time a new family member calls me, I'm like, tell me again who your sister is or who your mama is, and I'm literally drawing out a family map because I'm trying to understand it for the purposes of this deal, and doing my best to try to figure out. When you said that's your sister on Facebook, was it true, like a real sister, or like that's just me? But so how do you guys have anything else that you want to put? Do you guys want to give out these 2 books or the same book?
that guy has a great top topper set. I'm gonna give him one. I like your man bun, buddy.
Oh, thank you. Oh.
questions you guys wanna ask? Kevin, yeah, what's up?
I've got a deal I'm working on, so, trying to make an offer on a house. The person who owns it died last year. There's 4 heirs, but, you know, I guess there wasn't a will. Succession hadn't been opened. He died as a resident of another state. So, I guess my question is, you know, I talked to one of the heirs, and, you know, they're looking for something. And, you know, I proposed a solution, and I'm, you know, trying to get an idea of how much it costs and how long it's gonna take to complete that process.
So from the seller side of the transaction, so the cost associated with the succession, and I'm not gonna tell you a price off the top of my head because every situation is different and it gets more complicated and we're gonna take the time, we're gonna charge more for that type of work. Generally, because we're doing a succession and a closing at the same time, if we were handling the transaction, the succession fees are gonna be cheaper because we're getting the same information and kind of doing the work hand in hand. So from the seller side of the transaction, the fees will be more reasonable if we're doing a closing at the same time. But to break it down logistically, the cost of the succession are gonna be borne by the seller. The buyer isn't gonna be paying any part of that succession cost. And so if the sales proceeds are 50 grand, that cost of that succession is gonna be subtracted from their sales proceeds, and they're just gonna get, if we charge $2,000 of the succession and they're gonna walk away with $50,000, we're gonna subtract 2,000 from their 50, they're gonna split 48. And so another benefit of doing the succession and the closing at the same time is sellers don't have to come out of pocket for the cash. It all comes out of the sales proceeds of the transaction, and we can actually do the full succession and collect our fee from the sale of that one piece of property that we're transacting.
And in relation to that, because he lived out of state, so we could do the full succession for property in Louisiana. Home, right?
Yeah, so we would be opening an ancillary succession in the state to transfer ownership of that and move the property.
But, and in that situation though, you would not have to wait to get, other state, because you have to think of this, right? Sometimes people die out of state and they have property here, and they might not ever open the probate in that state, right? Or it might take them forever and ever. We don't want our property here in Louisiana to sit out of commerce, so you do have the right, somebody can act on their behalf to say, go to the parish in which it sits and just judicially open succession and finish that up. It needs to be an heir or somebody, right? But obviously, if there's someone interested in selling it, that'd be the person.
Did that answer your question? The cost of
Yeah, but I got a couple follow-up.
For
So,
sure.
you know, how does the fact that there's a tax lien on the property complicate
So-
succession? And then, you know, since he's one of 4 heirs, how do I enter into a valid contract to purchase the property?
Your first question, the tax lien, has it been 3 years?
No.
Okay, so when somebody pays property taxes and we get a closing within a 3-year period, we just have to call the assessor and get a payoff from the assessor. The assessor pays that person back their initial tax payment plus the interest that they're owed. So we call it, just like a regular payoff on a judgment or a mortgage, we're gonna call the assessor, they're gonna give us a payoff, we're gonna pay the assessor, and that lien will be cleared. And the sellers, again, will get the proceeds minus succession cost and tax sale, or tax lien costs, pay that off. And when it comes, what was the second question?
So it's, yeah.
Valid contract.
Oh, you would have to get all 4 people to sign, unless you just wanted to buy a quarter interest in the property, but I don't think you want to do that. You would have to get all of them to agree to the sale.
Anytime you're buying a property, you should get all owners, you
Yeah.
know,
Again,
husband and
it also-
wife, yeah.
It goes into what John said earlier, if you can have, generally you have to have more than one, right? So you might have to get 2, if you have 2 of the heirs agree, then you petition, you open the succession, because you only, how many heirs do you need to open the succession?
So it depends on.
Didn't you say 2, potentially 2?
It just depends on if it's a surviving spouse, it can be just a surviving spouse.
It can be.
But you generally need at least 2 people to sign certain documents, like certain affidavits. It doesn't necessarily have to be 2 heirs. But even so, though, if we do it that way, if there's no will, then there's no one appointed for independent administration. So you would have to get the signatures of the other heirs to either agree to the appointment to have one person sign everything, or if you just can't find them, have the court appoint curator ad hoc.
So what my point was, and look, we can talk about this after, since it gets into details and strategies for you on this deal, but you could open the succession through one of the heirs and then petition the court to sell the property because it's in the best interest of the estate and the other heirs won't agree.
Yeah.
And so, if you can get that one heir to agree, get the succession open, then you call your attorneys and talk to them how you can logistically force the other heirs to sell the property to you.
So a few pro tips I'd recommend here that I don't know if you guys are catching up on is I use I have paid for successions before. I use it just like paying for closing costs as a negotiation factor. So there are times, like I had this one woman who did not want to sell her property because she's struggling paying property taxes because she's like, if I can't even pay property taxes, how am I going to pay for the attorney fees? I'm like, let me make that in with my offer. I'll pay the succession. Here's my price with the, attorney fees included. I'll pay for closing costs, kind of bundle it in. So she's not thinking, how am I going to have an extra? And people, sometimes it's like this intangible fear of like attorney cost and all these things, right? They're like, well, I don't know how much it is, but it's going to be $1 million. But it's one of those things is, so I'd use that in my negotiating tactics is, look, not only can I pay cash and I'll pay for the closing costs, but I'll also pay for the succession. I don't always do that, but sometimes I do that if it'll help get it over the hump. The second thing is they're talking about some next level stuff. So if you come across a complicated property where only one person wants to sell, all you need is just one owner who's interested in selling, and there are legal options to take. Does everyone want to take legal options when it comes to buying properties? That's kind of the strong arm position, but there are options out there. So if you come across a property that is a phenomenal deal and you're really only dealing with one owner, just know that you have legal options out there. This year alone, I think I've been able to do, we're on our second petition where it's the legally forcing people to sell. Do I like doing that? No. I try to exhaust every other option before that, but in the state of Louisiana, you can't force someone to own the house with you,
So I would say the cost of the succession is dependent on the value of the complications of that succession. But again, if we're handling the closing and the succession at the same time, you get a discounted rate on the succession. The seller bears the cost, and it's going to be subtracted from their sales proceeds, so they won't have to come out of pocket for any money. If you go to a third-party attorney, they're probably going to want you to pay them up front, and so they'll have to pay for that. They come to the closing, probably get recouped as part of the sale, but they have to come up with the money. And then what was the third question again?
I think that was it.
That was it, right?
Yeah, I guess mainly what I'm trying to figure out is, the air wants 30,000, so, I'm trying to figure out, well, based on my, maximum acceptable offer, am I gonna be able to accomplish what they're looking for? Is it even a deal?
Is that what?
5,000, 10,000, 15,000
For the succession.
for success?
I wish we made something.
No.
Yes.
No.
No, it's much substantially less than that. I would say standard succession costs are about $2,000.
Yeah.
That is a full-on succession that's not related to a real estate transaction. After it's a part of a real estate transaction, it goes down from that.
Yeah, I wouldn't necessarily say that. Full on, all right, so that's a full on.
It's not more than
simple
$5,000
transmission thing.
typically.
Yeah, we're not dealing with a bunch of grumpy heirs who don't.
Yeah, I haven't dealt with a ton of crazy complicated succession, so I'm probably a little more lenient than John is. But it's a case-by-case basis is what we want you to know. But
Well,
it's not an exorbitant amount of money unless it's super complicated.
Correct.
So the question though is that what he's wanting to walk away with? Because he's not the only decision maker in the property. Anytime I come across anything where there's more than one owner, he may want 30, but is it him picturing himself walking away with 30,000 himself, or 30 to split among all the other co-owners? He's not the only sole decision maker. For example, the one with the 4 owners with the one dude who's sitting out, like that I've been trying to buy for a year. The guy thinks he's going to go list it with a realtor. He physically cannot sign to list it with a realtor without all other owners, because he's not the only sole decision maker. He can't go and sell the property without the title company saying no, everyone else has to sign. So that's one of those things, is kind of figuring out, why does he want that price, and what the other owners, where are they at in the thought of selling, is at the price that they want as well. And then you then go backwards from there, is can the property support that price point? between condition and value and, you know, the investor side of discounts and stuff. Does that kind
Why
of,
don't you give us a call if you have
Yeah.
any questions about it, we'll get in more detail and we have you strategize on how you can. do
all
that.
right.
Well,
Well,
more questions?
There's a quick question, really quick. They have a property, it's in another state, but I know it's different in every state, but,
We can't answer that question, it's out of the state. So,
if it was in Louisiana, like say, if it was Louisiana, so the woman, she did, she signed a contract, we sent her an offer, she signed it, we had her husband and her name because they were both on a record, but we didn't know the husband passed away. Is that a valid contract in Louisiana?
It
Just
can
having her
be.
signature, or?
If she were to inherit a successor prior to the appointment of administrator executrix, right, in a succession, can exercise his right of ownership, his or her right of ownership, so long as he eventually comes into that right of ownership, right? So if it's a piece of property that for some reason she isn't the executor, right? So let's say she signs it, okay, succession's open, then an executor is appointed or an administrator if it's intestate, and it's in the best interest of the estate to sell that property, then she can't be bound by it, okay? But if they don't sell the property, right, so it's kind of just basically a waiting game at that point.
so
Unfortunately.
our cards are in the back. If you have any questions, you need anything, you want to talk about logistics, about anything we talked about today, call us at any time. We take care of our clients, so if y'all want to help with real estate transactions, call us and we'll do our best to get you the.
None of this is legal advice. All right.
the fun level
You
is
gotta
there.
talk to us.
Do you guys want to give out one more?
You give it away. I feel
All
like I
right.
just threw a book at this guy.
You're like, man, bud, I relate. Okay. Who here is currently working on a succession transaction? Anyone? All right. There you go.
You already got a book.
I got it.
Yeah.
Yeah. All right, you guys. Thank you guys so much, John and Jared. Thank you. Well, thank you guys for coming. Next Tuesday during lunch, we have our next event. You guys have a great night. If you need anything on the back table, you're more than welcome to grab it.
Thank you.
Give away.
Got a really hard question.
What's up?
All right, so somebody has used it for the property.
Okay.
Lease it out this.
Turn.
Is it all?